applicant and the owner, John Ullman. John, if you could unmute.
Okay,
John.
I'm unmuted.
Great. Can you hear me all right?
You're fine.
Okay, fantastic. Welcome. We should get started here in a minute. Mr. Ullman, are you expecting anyone else to join us here today?
No, I am not.
Okay, great. See, we have some folks from the zoning department also with us. Trey, how you doing?
Good.
Welcome.
Well, good morning, Mr. Ullman.
Good morning.
Okay, I think we're ready to get started. And the last thing to do real quick before we do get started, though, is to read through our hearing script. This will basically just cover the procedure for the hearing, and then we'll jump right into it. So this is the January 18th, 2023 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati. The case before us today is case number ZH20220181. The purpose of this hearing is to allow applicants and any opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony or evidence that an applicant or any opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. If there were anyone here from the public, I would then give them the opportunity to speak after the applicant had presented its case. I'll give our zoning department an opportunity to provide any testimony in addition to their staff report. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to rebut that testimony and or argument that's been offered in opposition. And then finally, the applicant will have an opportunity to make any closing statements. So Mr. Ullman, for our purposes here today, I'll allow you to tell me more about the project, any background you think is important for me to understand, and then of course why you believe that I should grant this relief and why it's appropriate. I'll go and I'll give Trey an opportunity to provide any testimony. I'll go back to you. You can respond to anything Trey said and make any closing arguments. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties with the Zoom technology, I'll do my best to troubleshoot those on the fly, but to the extent there's some defect in the tech that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. All right, I think that's it. I need to swear in all of our witnesses. So if you intend on providing any testimony here today, the zoning code requires that I swear you in. So if that's you, if you could raise your right hand, I need everyone to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Okay, great, fantastic. All right, Ullman, are you ready? I'm sorry, Mr. Ullman, are you ready to proceed?
Sure. We've lived here over 20 years on Dillon Avenue and Mount Lookout, and been doing lots of improvements over the years, inside and outside. And there's now a need for additional space in our house, which is a one-story bungalow, as we call that. The footprint of the house is about 26 by 50 feet. And we want to add some space upstairs by expanding an unfinished attic that's currently accessible only through a hatch. And the need for that is basically we need more space. We need office space because of my wife's telecommuting, and also need space to accommodate visitors from out of town, family members. We went ahead and had the architect do our design, and we learned that we are in the hillside overlay, and this comes under different review than a normal application. In essence, this 26 by 50 footprint is going to stay the same. We're not expanding anywhere outside of the existing foundation line, and the back half of the attic area, about 26 by 26 square, will have the roof line raised about 7 feet. So there's headroom up there. The front half will keep the same roof line and have flooring put down, and would be a loft area, about 12 foot wide with knee walls. And the big issue that has come up is the fact that we are in the hillside overlay and the maximum building envelope calculations come into play. We're the oldest house on the street, dating to the 1920s. We're also the smallest house on the street. And our two neighbors adjacent have extremely large, for the area, properties, setbacks, rear setback in particular. And I think it's the left setback also puts us out of sync from the maximum building envelope perspective. So when you apply those dimensions to our dimensions, which are fairly or very reasonable within the SF6 zoning, you end up with a footprint that's unbuildable. The front property line overlaps the rear property line, and that's not our understanding of how the whole zoning code works, as far as trying to be harmonious within the neighborhood, et cetera. So we're asking for relief on the side and the rear setback requirements. We've had the geotech inspection done, and our the additional load for the addition is within spec, so we don't have any issues as far as the hillside goes there. So basically, we need relief on those two setbacks. Trey did a great job explaining to me how this whole system works, and that we need to go ahead and apply, and that's pretty much what we've done.
Okay, great. Yeah, that makes sense to me. I don't think I have any questions. I think I understand this one. I'm going to give Trey an opportunity to weigh in here. But we see these a lot with the hillside averaging. So Trey, is this one of those typical hillside averaging cases? I mean, looking at the cages, it looks like this would be tough to build here.
It is. I mean, David, I've only had a couple of these where it was this extreme, where it's, hard to even explain to the homeowner. I mean, Mr. Ullman's a super smart guy, and he got it, but it's tough to explain. It's almost to the point where the regulations, the way they're written, it could create a situation where the maximum building envelope is so skewed that it would make it an otherwise totally ample lot unbuildable. We had one about a year ago on Egbert. I had one with you where you literally had the rear setback in front of the front setback. It was that messed up based on the two adjacent properties. Here, you have a property adjacent to the south with a lot area of 1,600 square feet. The subject properties, by the way, is about 9,000 square feet, a little over that. And the property on one side, 16,000. And the one to the north is even more extreme. It's 26,000 square feet, which is huge for SF6. I mean, that's a 6,000 square foot lot requirement. Even less if it's a lot of record, right? If it's a lot of record, you can even have it less than 6,000, so at 4,800. So, and the lot depth is more than 80 feet greater than that of the subject property. This is the property adjacent to the north. So it just skewed it to the point, I thank Mr. Ullman for his patience, where you have an example like this where, 95% of the time the regulations are met, serve the purpose that they were intended to. But here, I think it's just to the point of absurdity that it skews it that much that that you literally would have an otherwise quite buildable lot. It's almost double what you'd need for a lot of record. It's instead of 4,800, it's 9,148 square feet. So, very sizable lot compared to for a lot of record with a house this old, and yet, basically it's unbuildable under the terms of the MBE. So I think, this is an example if I've ever seen something that, where the code is not serving the, the intended intent and purpose of it. This is clearly not. They're not increasing the footprint of the house at all, and then most of the roof that's being added will be screened by the additional by the part that already contains the attic. As he pointed out, they're going to do some kind of like an office loft there, and then a bedroom off the back. So anyhow, that's just seems like a case where the relief should clearly be granted, because it would be incredibly unfair. This is like the ultimate in undue hardship here. So
yeah.
And I thank you again for your patience in dealing with that fact, Mr. Ullman.
Thank you.
Yeah. I mean, when the lots are platted and developed, and homes constructed in the 1920s. Then we have a zoning code laid on top of that in 2004. It's inevitable that there'll be some of these anomalies. And so I obviously agree with both of you, and I've had a chance to review the application materials and the letters of support and the staff report. And I agree that it would be impractical to strictly enforce the zoning code here for a number of reasons. So based on all of that, based on the testimony I've heard here today, I am going to grant the relief. I need to formalize that approval in a written decision. I mentioned that that takes about 2 weeks. My queue is a little bit lower right now, so I'm hoping I can get that out to you sooner. As soon as I finish that, I put it into a PDF and I email it to everyone who's in the hearing here today. And so you all have a copy of that really just moments after it's complete. As soon as you have that, Mr. Ullman, you can work with Mr. Sheldon to approve all the permitting.
Thank you.
And hopefully get started at that point. Any questions about any of the process or anything else?
No, not this time. Thank you very much.
Okay, great. Thank you guys for your time and your testimony. Hope good luck with the project. Hope you have a great day. We're adjourned.
Take care.
Thanks, everyone.